is a legal analysis, and I guess different people would interpret it differently. And I do agree with the transfer overall, by the way. But I just want to make a comparison to the intent of this charter. I think just from my personal view, that I think the frame of the charter got it to the point where it's big enough and it's flexible enough for us to determine, just like a constitution. But I think that they were business people back then too, and as a business owner, even for apartment owner, just an example, if you get revenue from rent, a smart landlord owner would want to set aside different funds to, for example, let's go with those 4 funds so I can keep track of those. The electric revenues fund would be an example of a rental income. And then the depreciation fund would be a fund that would set aside to replace or repair, let's say, refrigerators, washing machines, so that you know it's going to get broken every year. So you want to set aside that depreciation fund for that replacement purposes. And number 3 is the sinking fund, which is the mortgage payment. You're going to pay a mortgage, the principal and interest, so you want to set aside that you recover, you have enough from the rental income to pay for the mortgage and for the taxes, etc. And then the 4th one is the surplus fund. In this example, from the building owner perspective, would be anything that would be net from the revenue. You subtract out the depreciation fund you set aside and the principal and mortgage payment you set aside. And so that surplus fund, I would assume, as a business person, that would go towards a fund that you would use for your profit. So additional profit can be made if your other funds are being covered. Then from that profit fund, which is the surplus fund, I assume, will be used to go back into the shareholder or the owner's pocket, or to be given away, or maybe to, if it's so much that they can give back to the renters, even though it's not likely. But I would assume that's the case for any surplus fund, that's the discretion and the option of the owner landlord, in this case the city and the city council, to decide what to do with that surplus fund. But like any building owner, if the revenue doesn't cover or just covers the depreciation fund and the sinking fund to pay your mortgage and principal, then there wouldn't be any excess surplus fund for profit. So therefore, I would assume in this case that the city council, if there's no surplus fund in the surplus, as a profit in the surplus fund, then there wouldn't be any transfer. Even though I agree that potentially it should be budgeted, because like any investor-owned utilities, there is an obligation of the utility to provide revenue for the shareholders, in this case the public of the city, the citizens of the city. And so I support that perspective from the city council to budget those transfer in the operating revenue. So from that perspective, I think we can transfer it, but I assume that the framer of this charter had that idea in mind, that the depreciation fund should be adequately funded so that you can repair and replace refrigerators, washing machines, as an example, from the building owner, and then of course the principal and mortgage payments. So that's all I'm going at, is that I do support the transfer, but I think that we have to look at it from that perspective, that there are certain funds that are designed to cover what a business person would normally see. So hopefully we get to that point where we minimize the discussion on what transfer, why we're doing this or that, but I think we just have to know that these funds should be adequately funded and the transfer should still take place, but it should be taking place knowing exactly what is being done and how those revenues should be going to pay for these different products and services that the utility offers. Thank you.
Other questions? I have a couple. So on slide 18, I want to continue with Commissioner Yao's statement, because I think the question at this point is not just, is it legal or is it not legal to transfer. I think the questions and what we're facing as a dilemma is, over the years, what have been the more subjective judgments that have been made by deciding bodies in balancing the needs of the utility versus the needs of the city with the general fund. And now with a bad economy, we have our backs against the wall a little bit, where the utility needs funds to do a variety of projects and is having to go back to customers to get those additional funds. If you look at some of the issues with regard to the surplus fund and the depreciation fund, if you were looking at those funds a little bit more conservatively over the years, knowing what a capital-intensive business it is to maintain a utility, you would have been more conservative in the amounts that you would have transferred out of the utility versus what you would have kept in as part of your funding mix for future CapEx. So, for example, on this particular slide, we talk about, the credit balance, if any, in each of these said funds at the end of the fiscal year, the amount of which is in excess of the amount of all outstanding demands and liabilities. Again, some of the devil is in the details of the definition of what are the outstanding demands and liabilities, not just in that year, but in coming years for the utility, which might define how much money you reserve within GWP to fund those sorts of things. Same with, if we go back to slide 8, the depreciation fund. This is potentially one of the funds from which you would be funding important capital expenditures, but have we been reserving enough funds within this fund to, again, plan for future expenditure needs? And I think we've backed up over the years of depleting our capacity as a utility to fund moving forward. So I guess it's more of a statement than a question, because I think that with all these funds, if judgment were applied in a somewhat more objective way, and if the GWP staff over the years had advocated more vigorously about maintaining some discipline of what's maintained within GWP and these various funds, because of, again, looking forward and the needs of the GWP to maintain kind of the integrity of the operation, I think, perhaps past city councils might have been a little bit more conservative. But I fear what has happened over time is that whenever there's been a budget shortfall, one of the ways we tend to make it all balance out is by transferring more at moving funds around within the city and making that balanced budget appear. But now that revenues are lower and times are tighter, we're in this predicament of now we've kind of depleted the bank account, if you will, and now have to go back to the shareholders to say, give up, deposit more money in the bank account, please, so that we can maintain the operation properly. So, I think part of the lesson here is, aside from the debate here about, is transfer legal or is transfer not legal, is the issue of how much does GWP kind of advocate in behalf of GWP, even though it's part of the same city. At the same time, the first responsibility of GWP staff is to ensure that you're advocating for maintaining the integrity of the system, including kind of looking ahead and what are the needs going to be coming up. And maybe it goes even beyond the 5-year mark, and it should be even further than that because it's such a capital-intensive business, so that we don't find ourselves in these situations. Because at the end of the day, the argument needs to be supported when you go back to the public and the people paying the bills, that you did everything you could to plan for these major CapEx needs. And if we said, well, sorry, we haven't really saved enough for this, and so our choices are two, right? Bond or raise rates so that we can increase the revenue coming in. And I think that's should be part of the discussion when you go to council, is this starting this conversation about moving forward. We really need to be very judicious about how much we transfer, where the first priority needs to be maintaining the integrity of the system so that we're not depleting it. Then we can look at where else we might spread some of the revenue to cover other needs as well in the city. Because if the system falls apart, then everything falls apart in the city.
Can I follow up on that?
Yeah.
I thought that both of your remarks were really excellent, and I appreciated listening to you. And I think that both of the commissioners have articulated things that members of the public are feeling, and that while something may be legally defensible, and we really appreciate the work, the research, the analysis, I know this is just an information item. We're not adopting your analysis. You're just sharing it with us. And so I can tell that you've done a lot of work to make this legally defensible, and I hope it is, and I appreciate understanding the analysis. But then there's the secondary thing, which you've just heard. With that in mind, this question occurs to me. Is there, from the city attorney's point of view, your professional duty is to the city as a whole, as to the city as one entity? If I understand the way the assignments work in the city attorney's office, you happen to be assigned to be the legal advisor to the GWP, correct?
That's correct.
Are you the legal advisor to the GWP and also to the GWP Commission?
Well, I do advise this commission, as you know. Technically, my client is the city of Glendale, but I specifically represent Glendale Water and Power. So
it strikes me that there's something, I don't want to call it a conflict of interest, that's putting it too, that's going too far. But I just wondered if you could share with us any thoughts you have about the fact that really the city attorney is defending on behalf of the city as an entity. Really, your professional obligation is to defend the transfer, essentially, because that's a decision of the city to protect its general fund. But you're here today in your capacity as legal advisor to this particular department. And it's just occurring to me, listening to the dialogue, that because it kind of seems like there should be an independent attorney on this matter, because don't you have some conflict in the two duties?
No, I don't think so, and let me explain why. My role as an attorney in general is to provide a truthful outlook of the way I see the law, the good and the bad. And if you'll recall back to when this commission and the city council was considering the issue of Proposition 218, our office came out with an opinion that, in fact, that transfer needed to be discontinued. Very bad for the city, potentially good for Glendale Water and Power, but our job and our role is to provide an impartial analysis. So we need to present the risks to the city as well as what we consider to be accurate. So I could not come before you today and present to you what I think is, an inaccurate version of the law. I mean, that would be potentially malpractice. So I need to come before you and tell you the law as I see it, and that's what I've done. And that's what I'll continue to do.
Absolutely. I understand that. It's just occurring to me. I think what I said maybe wasn't as clear as it could be, and maybe I'll talk to you about it another time, or send you an email. I didn't mean cast any aspersions on how you're advising your client. I'm just noting that your client is the city, and its general fund is what your client draws from to operate itself as an entity. And then over here we have a utility that needs potentially to raise revenues to pay for its operations. And to some extent it's inherent in your performance of your duty to the city as your client to defend the transfer of the general fund.
And there's no question there's a tension between the departments in this case. I mean, not everyone's going to end up happy with this result. But, the charge to me was look at this issue and is it legal? It wasn't, do your best to find that this transfer is legal because the city darn well needs this money. It was take an impartial look at this, research it thoroughly, and give us your opinion. And that's what I, in conjunction with Mike Garcia, the city attorney, have done.
Well, that's why I think from a legal analysis perspective, part of the issue is just the very objective analysis, but then part of it, some of the terminology. I'm not a lawyer, but but based on the terminology that exists in the charter, I think could be interpreted subjectively based upon who's interpreting it. And that's not to say to the point of it making something that we're doing today from legal to illegal, but I think in terms of the judgment that it suggests in terms of how we manage some of these funds, I think there's two ways to interpret it. There's the, is it legal? Are we okay? How far can we, push this within the bounds of it being legal? And then there's the way, well, what's prudent to do in terms of protecting the interests and the sound operations of GWP. And I think while we look at it all as one city and GWP is part of the city at the same time, I think there is a need for GWP to be able to advocate without any retribution the sound management of the utility and advocating that that a certain amount of funds be reserved. And I think part of the challenges in operation like GWP, a lot of it is long-term capital spending, and so it's easy to, it's very easy and tempting to adopt a kick the can down the road type of budgeting process by a city, and then a future city council will have to deal with the consequences. Well, at the end of the day, there's eventually an end to that road where the bills come due, and that's kind of the situation we're in today. So, I would hope from a philosophical perspective and a culture perspective that both city council as well as city management and city manager would consider a little bit of this dilemma that GWP staff need to have the room to advocate in behalf of the sound management of the utility, if that's the business we're going to be in, which requires saving appropriately in the variety of funds which serve as funding mechanisms for some of these major things.